Hello, my name is Gavin Dowd from Trinity FLAC, and over the past 2 weeks we have teamed up with Trinity Politics Society to bring you the Referenda in Review series. This is our final instalment, and we've been looking back at a select number of referenda over the past 20 years in Ireland, why they were proposed in the first place, how they affected the status of minority groups, and whether or not they achieved their aims. We're reflecting on how Irish society has changed over the past 2 decades, during which there have been 19 referenda put before the electorate. In this instalment, we're considering the 2004 Citizenship Referendum. Now, if you're a student watching this, it's almost certain that you didn't have the right to vote in 2004, and it's probably quite likely that you didn't appreciate the significance of the referendum at the time. So just to remind you, this referendum approved the 27th Amendment to the Irish Constitution, which effectively removed the automatic birthright citizenship of children born to non-national parents in Ireland. There was a turnout of about 60%, and nearly 80% of the electorate approved this referendum. We're going to look at the past, the present, and the future in this instalment. You'll firstly hear from Dr. Ciara Smyth. She's from NUI Galway and has researched extensively in the areas of refugee law and human rights law. She's going to be looking back at the context at the time of the referendum, the legal background to it, a number of court cases that preceded the referendum, and perhaps the political ulterior motives for holding it. Secondly, you're going to hear from Professor Eoin Devereux from the University of Limerick. Professor Devereux, alongside 2 other academics, published a piece of research considering how the media framed the referendum debate, the media coverage of it, and how the media failed to properly counter xenophobic statements that were made during the course of the debate. Then we'll turn to the present and the future, and you'll hear from Bulelani Mafako. Bulelani is a representative of MASI, the movement of asylum seekers in Ireland. He's going to be speaking about the significance of the referendum from the perspective of asylum seekers, how the referendum affected asylum seekers, and how people can get involved in campaigning. Lastly, you're going to hear from a group of Trinity students, TCD Against the 27th. This group formed in light of the Black Lives Matter movement earlier this year, and they'll be speaking about their grassroots campaign to change the law in this area. Welcome to the final instalment of Trinity FLAC and Trinity Politics Society's Referenda in Review series, and we hope you enjoy.
Hello, my name is Ciara Smyth. I'm a lecturer in the School of Law and the Irish Centre for Human Rights at NUI Galway. I'm Programme Director of the LLM in International Migration and Refugee Law and Policy. And many thanks to Trinity College's Student FLAC Society for inviting me to this talk today about the 2004 Citizenship Referendum. So the 2004 referendum was slightly unusual. It was quite a quick referendum. It was rushed through, at first announced in March 2005, with the actual referendum taking place in June. And I wrote an article about it at the time with Donnacha O'Connell called The Citizenship Referendum, a Solution in Search of a Problem. So I think you'll appreciate the angle that I'm going to take in this talk. So I just want to ask a number of questions in this talk. First of all, I want to ask, what did the citizenship referendum do? In other words, how did it change the Constitution? So that's the first thing that we need to understand. Then I want to ask, why the need for a referendum? What were the official reasons that were put forward to justify a constitutional referendum? And the third thing I want to ask is, really, were these questions that were put forward really valid? So I want to sort of destabilise the justifications for the referendum. And then finally, I want to interrogate what was the real reason for the referendum, and I want to put forward certain of my ideas there. And of course, you're free to agree or disagree. Okay, so let's start with the first question then. What did the 2004 referendum do? Well, in order to understand the change to the Constitution, we first need to visit Article 2 of the Constitution, which was inserted or at least amended in 1998 at the time of the Belfast Agreement. And Article 2, and I'll read it out in full, Article 2 says, "It is the entitlement and birthright of every person born on the island of Ireland to be part of the Irish nation. That is also the entitlement of all other persons otherwise qualified in accordance with law to be citizens of Ireland." So this was popularly understood to be a kind of a constitutionalizing of the jus soli principle. So the jus soli principle is a method of allocating citizenship that's typical in common law countries, whereby you acquire citizenship by birth on the national territory. So anyone who's born on the national territory is automatically ipso facto a citizen. And this jus soli principle was previously there in ordinary legislation. But when the Belfast Agreement came to pass in 1998, this, of course, required us to remove controversial Article 3 from the Constitution, which basically asserted sovereignty over 32 counties in Ireland. But that was problematic because then what about the Northern Catholics, the Northern Nationalists? Were they now disenfranchised? So Article 2 was amended, and that's why we have this reference to the entitlement and birthright of every person born on the island of Ireland to be part of the Irish nation. So it was a sort of a sop to the nationalist community in the north. So when Article 2 was amended in the Constitution in 1998, people regarded this as putting the jus soli principle, which we always had, on a constitutional footing. Now, I'll come back to whether that was a correct interpretation in due course. So what did the Citizenship Referendum in 2004 do? Well, it didn't amend Article 2 directly, it amended Article 9, and it established that persons born on the island of Ireland to non-national parents are not entitled to be citizens unless it's provided for by ordinary legislation. Okay, so it deconstitutionalized the jus soli principle only for people born to non-national parents, and it sort of parked whether they would be entitled to citizenship into ordinary legislation, and then that ordinary legislation was subsequently adopted, the Irish Nationality and Citizenship Act in 2004, and that act provides that non-national parents must have been resident for 3 out of the 4 years preceding the birth of the baby in order for the baby to be considered an Irish citizen. So not only does it deconstitutionalise the jus soli principle for non-national babies of non-national parents, but it also departs from the pure jus soli principle because now parents have to be legally resident for a certain minimum period of time before their children will be entitled to citizenship. Okay, so why was this referendum needed? Well, the reason all relates back to the so-called Irish-born child phenomenon. So this phenomenon was people were coming to Ireland, claiming asylum, having an Irish child, getting residency on the basis of the Irish child, and then withdrawing the asylum claim. Okay, that in a nutshell was the Irish-born child phenomenon. Now, this was never fully backed up by statistics. We never received any disaggregated statistics on this phenomenon, at least none that were made publicly available. But there was anecdotal evidence of asylum-seeking women arriving in Ireland at late stages of pregnancy and making an asylum claim, withdrawing their asylum application. And certainly the asylum figures in Ireland had increased exponentially in the decade between 1992 and 2002. So that's the decade that Ireland really changed from being a country of net emigration to being a country of net immigration. So in 1992, there was only 39 asylum applications in Ireland. And by 2002, there was nearly 12,000 asylum applications. Now, at that time, I was working in the asylum field in Dublin, and certainly there was a lot of sort of panic and a lot of effort made to establish a refugee status determination procedure. And there was worry at this time that this procedure that, you know, had taken a lot of effort to put in place and backed by legislation, of course, was being destabilised by the so-called Irish-born child phenomenon. Now, the fact that parents could get residency on the basis of their Irish-born child had been established in an earlier case back in 1990 called the Fadjujonu case. The Fadjujonu was a family of comprising 3 Irish children, and their parents were irregular migrants who had lived in Ireland for a long period of time, and they sought to resist deportation on the basis that their children were citizens and therefore the parents were entitled to residence in Ireland. And the Supreme Court agreed on the circumstances in the case and said that although the right of parents to reside in Ireland wasn't absolute, and that it could be rejected or at least limited, for reasons associated with the common good. There was no reasons in the present case associated with the common good that would override the rights of the family, and in particular the rights of the children. So Fadjujonu seemed to establish the precedent that if couples had an Irish-born child, they would automatically get residency as a result. So because of the supposed constitutionalising that had happened with the Belfast Agreement, with amended Article 2, and because of the Fadjujonu precedent whereby parents of Irish-born children automatically got residency, it was felt that there was a need to change the constitution, and that, in essence, was the impetus for the 2004 Citizenship Referendum. So now I want to ask, well, was this really the case? And in actual fact, if we dig a little deeper, we will find out that not all of these reasons were actually valid. So the residency issue, the issue whereby parents, non-national parents of Irish children automatically got residency, had already been taken care of by a 2003 Supreme Court judgment in a case called Lobe and Osayende. And essentially what Lobe and Osayende did was it took the Fadjujonu precedent. It didn't overrule it, but it distinguished it in the facts. And it said, basically, whereas Fadjujonu consisted of a family with 3 Irish children, they'd been in Ireland for a long time, and there were no compelling reasons associated with the common good to ask that family to leave, because there was practically no immigrants in Ireland at the time, that the factual situation had changed so much in the intervening years. And then, in fact, Lobe and Osayende were asylum seekers. They were in Ireland for a very short period of time. They just had Irish-born babies. And that for reasons associated with the maintenance of the integrity of the asylum system, it was important that those parents wouldn't be allowed to stay. And so Fadjujonu was distinguished, and Lobe and Osayende essentially decoupled the issue of citizenship from the issue of residency of non-national parents. So in a sense, the problem was already taken care of in 2003. But then later in 2003, EU citizenship became the focus of the government's campaign and the government's rationale for holding a citizenship referendum. And this was on the basis of an opinion that was given by an Advocate General in the European Court of Justice, as it then was, in a case known as the Chen case. And essentially what happened in the Chen case was that a Chinese woman was resident in Wales and had been advised by her solicitor to travel to Belfast to have her baby and then go back to Wales. And so she did that, and she had her Irish baby in Belfast with Irish citizenship, moved back to Wales, and then sought to assert on the basis of the baby a right to free movement. So the baby was an Irish citizen, exercising free movement rights by living in the United Kingdom, pursuant to a directive that no longer exists. It's been replaced by the Citizenship Directive. And this directive was known as the Playboy Directive, because essentially this directive was directed to people who were not workers, but were of independent means, who had health insurance and had enough independent means that they wouldn't be a drain on the public resources of the member state that they were travelling to. And so EU law provided that these type of people of independent means, these type of EU citizens, could indeed move from one EU country to another. And in the Chen case, the Advocate General held, or rather advised, that the mother in this case should also be given residency rights pursuant to the child's exercise of free movement rights, because if the mother didn't get to be with the child, then that would frustrate the child's free movement rights. So basically, when the Chen opinion, and basically at this point in time, it was only an opinion, we had yet to wait for the full judgment of the European Court of Justice. So the Chen opinion was sort of seized on by the government. And the government said this in its proposal for a citizenship referendum. It said, people with no other claim to be present in the EU and no substantial connection with Ireland are arranging their affairs so as to ensure the birth of a child in Ireland in order that it will acquire this status and these rights with an eye to increasing the chances of the parents securing for themselves by association with the EU national child, some claim to be able to remain within Ireland or the wider EU. So citizenship tourism, EU citizenship tourism was essentially what was been alleged here. Now, in actual fact, there was no evidence that this was occurring. And indeed, the Chen precedent was likely to have very little traction because it only applied to people of independent means. And in actual fact, most asylum seekers do not fall into that category. So the combined effect of the limited traction that Chen was going to have, the fact that Lobe and Osaende had decoupled the residency from the citizenship issue, meant that we were already seeing a huge drop in asylum numbers. So basically, in 2003, 8,000 people had applied for asylum, and by 2004, half that number, almost half that, just over half that number, 4,500 had applied for asylum. So we'd already seen the workings out of this issue by virtue of the Supreme Court decision in Lobe and Osaende. So in actual fact, the problem was already solved by the time of the citizenship referendum. And finally, there was a big question mark over whether jus soli had really been constitutionalised in Article 2. Remember now that Article 2 reads as follows. It says, "It is the entitlement and birthright of every person born on the island of Ireland to be part of the Irish nation." And indeed, in the Lobe and Osaende case, Justice Hardiman questioned, was it Hardiman? Excuse me for a minute. It was Hardiman. Justice Hardiman questioned whether being part of the Irish nation was actually the same thing as being an Irish citizen. And he said it was unclear to him whether Article 2, that first sentence of Article 2, conferred as opposed to acknowledged any citizenship right. So it was questionable whether jus soli had really been constitutionalised in Article 2 at all. So, in other words, the arguments that were preferred by the government really withstand scrutiny. So what were the real reasons then for the referendum? Well, in my view, the real reasons relate to what I'm going to call effect. Now, we often talk about effective citizenship. And what effective citizenship is, it's how citizens are encouraged to feel about themselves and others in order to validate decisions about inclusion and exclusion within the polity. So effective citizenship is something that is often spoken about in the literature. But another thing that's also spoken about is the politics of effect. And the politics of effect is the use by politicians of emotion in order to mobilise electoral support. And we're all quite familiar, whether we know it or not, with the politics of effect in this era of Trump and Brexit and so on. So according to, or under the theory of the politics of effect, citizens are encouraged to have a number of anxieties that politicians then fix. And politicians get kudos then for fixing this anxiety, which in a sense they have contributed to creating in the first place. So in this case, citizens were encouraged to have an anxiety about non-nationals, and in particular non-national women, seeking to come here at late stages of pregnancy, seeking to abuse not only the immigration and asylum system, but more importantly, abuse the citizenship Ireland. And these people, in fact, had very little connection with Ireland. So in my contention is that people were encouraged to feel anxious about this supposed phenomenon in a way that then politicians could turn around and fix. So I just want to give you an example of the politics of effect in a statement that was made by the Minister of Justice at the time. He said, "The government is convinced that in order to address the real issues posed by women putting themselves at risk or being put under pressure by their partners to take that risk, by undertaking hazardous journeys late on in their pregnancy, we must address the incentive that induces them to make the journey." So this is a kind of a classic statement revealing the politics of effect, because on the one hand, it's presenting the minister as being benign and caring for these women, but at the same time, it's also maligning these women and their partners as doing something quite underhand. So it's my contention that what we saw in the 2004 citizenship referendum was a solution to a problem that didn't actually really exist. It was a problem that was created in the public mind by politicians for the purposes of the politics of effect. And it's no coincidence in this regard that the citizenship referendum coincided with local and European elections. And I'm sure it was the thinking that this issue of the citizenship referendum would be appealing to the electorate, and that it would get them to turn out to vote in what was otherwise predicted to be a low turnout election. Thank you very much.
You're very welcome to the talk. My name is Professor Eoin Devereux. I'm a cultural sociologist based at the University of Limerick. one of the things I've been researching over the years has been the issue of how media portray issues concerning immigration, ethnicity, and so on. So in the short talk, I'm going to talk a little bit about some work that I did with Professor Michael Breen and Dr. Amanda Haynes of University of Limerick when we looked at media discourses around the 2004 Citizenship Referendum. A team of researchers, we have been interested in examining the relationship between media discourse, how media explain the world to citizens, and how that has an impact on public action or public inaction, and how media discourse has a bearing on public knowledge and understanding of issues that are sometimes contentious in society. I used a framing theory approach in examining media discourse, media coverage of the 2004 Citizenship Referendum. Media frames, according to Entman and Rees, are those organising principles which serve to structure information through the processes of selection and salience. In other words, news stories are packaged. They are told in a particular way. They use certain interpretative frames, templates to make sense of the world. So instead of thinking about news coverage being objective and neutral, we're interested in looking at the way in which stories are packaged, the way in which they are structured, and the kinds of interpretive frames that are often used routinely to explain the social world to audiences. So here are some common frames that you might discover in everyday media coverage in Ireland and elsewhere. The idea of the bloated public service, the idea that the health service is inefficient, workers who are striking are sometimes described as militant, immigrants are often described as being illegal. We can think about the phenomenon of Beatlemania, the idea of a tsunami, of turbulence, of the SARS epidemic, or indeed the COVID-19 pandemic. You can think about the way in which media commentators will routinely refer to the notion of the obesity time bomb. So frames are part and parcel of media content, of media coverage. And again, I want you to think about the fact that media content, even though journalists and others might talk about the idea of being objective, of being neutral, of merely holding a mirror up to society, what we recognise is that certain kinds of frames are used to explain the world to us. And these frames have an importance in terms of how the wider public understand phenomena. One way of thinking about what happened in 2004 is to ask ourselves, how well did the mainstream media in Ireland explain the citizenship referendum? We examined two broadsheets who were urging a no vote, and there were some interesting patterns in terms of the coverage there. More generally, when we looked at media coverage across the range of mass media in Ireland, we saw that there was a particular emphasis on the idea that the existing immigration system in Ireland was being abused and exploited. When we dug further, we noticed a recurrence of certain templates or frames focused on the idea of abuse, of the loophole, of the referendum, quote, closing the loophole, on the idea of immigrants exploiting a particular situation. There was a focus on asylum and the asylum-seeking process. There was a particularly gendered focus on the issue of maternity hospitals in crisis. And of course, there was an emphasis in coverage on the idea of citizenship tourism. The use of these frames or templates, they matter. They matter because they shape and influence public perceptions of what are sometimes complex social phenomena. So they matter, and it matters that we look and we unpack what the coverage is saying at a particular point in time. And in our wider research, we were interested in looking at the connections between media discourse and public beliefs about immigration, about asylum seeking, and so on. So media frames matter. The templates that are used matter. The language that is used in media content, in media coverage matters. And it matters for this reason, in that there are situations within media coverage whereby a story or a frame or a template gains currency, and it begins to become quite influential in shaping public perceptions about a phenomena, in spite of it not necessarily relating to any empirical reality. One of the templates used in media coverage of the 2004 referendum refers to the crisis in the maternity hospital sector. There were 30 stories which dealt with maternity and maternity hospitals at the time. This idea of the citizen tourist, the pregnant citizen tourist, a highly gendered construct, was strongly in evidence within media coverage. Now, this is despite the fact that there were relatively low numbers, 1 in 4 births in Dublin hospitals in 2003 were to non-national mothers. And it's interesting, even where you look at the data for hospitals in 2003, Dermot Doyle, for example, found that the mothers in question were from the United Kingdom, the United States, France, Germany, Nigeria, New Zealand, and a whole host of other countries. And the vast majority of births to non-national mothers were to mothers who were living entirely legally in Ireland. So while the 2 broadsheet newspapers we examined in very close detail had very critical coverage of events in 2004, Irish media discourse more generally reproduced and disseminated a debate that is best described as inadequate. We know from looking at media coverage in 2004 that many negative media frames concerning immigration predominated, and very little countering of public xenophobia took place. The reproduction, rather than the challenging or the holding of truth to power that much journalism talks about, of problematic xenophobic statements made by many politicians concerning citizenship, was particularly noteworthy in media coverage at this time. So really the work concludes that media coverage matters, media content is important, that certain kinds of tropes, certain kinds of frames or templates are used in explaining phenomena in relation to immigration or class or gender, indeed the whole social world. And our task as students of law, our task as citizens, as students of media, as members of society, is to think about the veracity of claims that are made in media, and crucially, the impact, the power that these discourses, these frames have on shaping public knowledge and understanding, and crucially, whether or not these frames have an impact on what people do. In other words, how they vote, how they perceive of difference, how they perceive of phenomena like immigration. Thank you for watching. Thank you.
The name is Bulelani Mfato, and I'm one of the spokespersons for MASI, the Movement of Asylum Seekers in Ireland. For us in MASI, the citizenship referendum had a significant impact on the lives of children who were born in Ireland to non-Irish parents. It meant that they could no longer have a right that they had enjoyed before, which is citizenship. It reserved Irish citizenship and all the privileges that come with citizenship for somebody who had already an Irish citizen parent. And that meant that a lot of children who were born here may face the threat of deportation. And in fact, several children have been deported from Ireland who were born and raised in Ireland. The most recent one was a 10-year-old who was born here, grew up here, and was taken by the Irish state and forced to go and stay in Nigeria, a country he knows nothing about other than that his parents came from Nigeria. And there are children today in Ireland, some in direct provision, who were born to non-EU nationals, born to parents who don't have Irish citizenship and don't have any pathway to getting that citizenship. There are a number of things that ordinary people can do to change the situation, and the first of would be to contact the TDs to ensure that when the bills are tabled in the Dáil, they actually vote in support of them. So TDs need to know that there are Irish people who care about the children who are stripped of their right to citizenship and the privileges that come with citizenship. And so we will launch an Email Your TDs campaign. We'll work with Uplift to get people to send the letter within less than 30 seconds, really just a few clicks, and it will be sent to your TDs and the relevant ministers. The other problem that we'll encounter then is that the opposition which is bringing the legislation forward is actually not cohesive, because we now have two bills seeking to address the same thing. And so what we do need in the Dáil is TDs working together on a cross-party issue, and make this a cross-party issue so that it can actually be passed, because now we'll have two bills before the Dáil, and which one is going to actually be voted in and passed is whole mystery. And so we need more coordination, especially amongst the opposition, because the two bills are actually being tabled by the opposition. We've had former Taoiseach Leo Varadkar saying that children should not be deported. Children who are born in Ireland should not be deported, and there are current children who face deportation orders today who have been born and raised in Ireland. And so we need people to put their words into action. So if Leo Varadkar doesn't think that children should be deported, then he needs to vote in favor of the bill. And we'll be appealing to all members of all people who are affiliated with political parties and those who aren't affiliated with political parties to contact the TDs and other public representatives to speak out on this issue. Thank you.
Hi, my name is Owen, and I'm the Legal and Content Officer for TCD Against the 27th. Today, I want to talk to you a little bit about the 27th Amendment and how it affects all those born on the island of Ireland. The 27th Amendment was introduced to reverse the effects of the 19th Amendment of the Irish Constitution, which was passed following the ratification of the Good Friday Agreement. The 19th Amendment of the Irish Constitution guaranteed birthright citizenship to all those born on the island of Ireland. Following its passage in 2004, the 27th Amendment removed this right to birthright citizenship, and subsequent legislation passed in the Dáil now regulates this area of law. So what are the effects of the 27th Amendment of the Irish Constitution? If you were born on the island of Ireland on or before the 31st of December 2004, you are entitled to Irish citizenship, or you are an Irish citizen. If you were born on the island of Ireland on or after the 1st of January 2005, you are entitled to Irish citizenship, or you are an Irish citizen if one or both of your parents are Irish, British, or allowed to reside in Northern Ireland or the Irish state without restriction on their residency, or have been resident on the island of Ireland for 3 of the 4 years immediately prior to your birth, or have been granted legal refugee status in Ireland. However, there are many children who do not fall into these categories, and they face great legal uncertainty over their future and even risk of deportation from the country where they were born, have grown up, and indeed the only country that they have known.
Hi, I'm Gabrielle, and I'm the Outreach Officer for TCD Against the 27th. I'm going to be talking about what we're doing and why we're doing it. Citizenship matters. It dictates our rights to work, to education, and to voting rights. The 27th Amendment was brought about under the racist lie that individuals come to Ireland specifically to have children and obtain citizenship. The reality is that this was never the case, and has resulted in a situation where children currently lack security in their home country. The 27th Amendment has an important relationship to direct provision also, as one of the reasons it was brought about was to avoid the legal ramifications of having Irish citizens born in direct provision. The consequences of the 27th Amendment can be changed through legislative action to make citizenship more accessible. People affected by this legislation are 16 now and will be seeking access to higher education funding soon. Now, more than ever, this is a student issue. TCD Against the 27th is a grassroots movement of students mobilising for migrants' rights and birthright citizenship. At the moment, we support the Irish Nationality and Citizenship Bill, Citizenship for Children 2020, raised by Deputy Barry and is in the second stage of the DUL. This will amend existing legislation so that every person on the island of Ireland is an automatic Irish citizen, and any child who has been a resident of the island of Ireland for 3 years in a 4-year period shall be entitled to be an Irish citizen. The basis of the law is material, and it shows how we respect and value members of our society. Let's treat migrant children with the respect and dignity that they deserve.